Hi, everybody. I hope you're having a good afternoon. Hey, Andy. I'm so happy you've been going live, going over that stuff lately. So it's really good to see you here. Sorry if my voice is a little scratchy. I'm just getting over being sick, but my bar studying has not been as productive as it has been when I've been going live. So I knew I needed to come live and try to get some stuff done today. Um, hey, Andy. It's good to see you. I really liked your live earlier. Um, okay, so I'm going to just jump back into torts. We're working on negligence, and right now I'm going through my torts flashcards. And torts are just like personal injuries, things that you sue for, like in civil court. So if you get into a car accident or someone defames you or steals from you, those are all torts. Okay, so my next flashcard is what is the eggshell skull rule? And if I remember right, this is the rule that even if you like negligently hurt somebody and they're very like fragile, you're still responsible for the damage you cause, even if you didn't expect it to be that bad. Yes. Um, yes. You, excuse me, you are liable for all injuries to plaintiff um, if even if pre-existing condition made it worse. So if you I don't know if you this is like a very simple explanation, but like if you scare someone but you don't know that they like have really like severe PTSD and they I don't know they go through a lot of emotional damages, you would still be responsible for it, even if you just thought they were like had a normal, maybe not normal, but like they didn't have that PTSD, you didn't know that, you would still be responsible for however much you scare them. Okay. The zone of danger. The zone of danger is when you're negligent and so this is for the negligent infliction of emotional distress. So sometimes, like if you get in a car accident and you don't get hurt, but you watch someone else get hurt, that can be a negligent infliction of emotional distress. So, like if the accident was caused because someone like negligently turned left, they would also be responsible not only for the physical um, injuries they caused to the person, but also to like people who saw that happen. So the zone of danger rule means that to sue someone for negligent infliction of emotional distress, you must have been in the zone of danger. And there's something else about being related. I have to look. No, let me go back. Yes, you have to be in the zone of danger. And the threat, the physical threat caused distress. Okay. When can a bystander outside the zone of danger recover for negligent infliction of emotional distress? Um, a bystander, if they're not in the zone of danger, so they didn't like perceive the thing happening, if they are related to the person, I believe that they can recover. All right, I'm not doing so great here. There's three things. Okay, not so if you're outside the zone of danger, must be closely related to the person hurt. You must be present at the time and personally observed. Okay, that makes sense. So there's two ways you can collect for negligent infliction of emotional distress. If you aren't the person who got physically harmed. You can either be in the zone of danger, so you almost were getting hurt. Um, and if you are not within the zone of danger, you might still be able to collect if you were closely related to the person hurt, if you were present, and if you personally observed the thing happening. Hey, Andy, UK authorities 1962 case, let me put this up. Smith versus Leach, Brain 2, QB 405. I just like the names of some of those cases. I really like the English cases, and I really like when there's some rules that are just so old, like we don't have an American case to go back to. So I like the old property rules that cite back to like really, really, really old English cases. That's impressive that you remember that. I'm so bad with case names, so bad with case names. Yeah. I always have to come up with like tricks to remember them. And well, no, I won't say that. Okay, let's me go to my next one. So in negligence, when are damages for economic loss allowed? I want to say no time, but I think that's not right. I think there might be one time you can sue for economic loss, and I can't remember what it is. Economic loss, so you can only collect for okay. So for negligence, you typically cannot sue just if someone's negligence caused you to lose money. But if they caused you other harm and they caused you to lose money, you can add the money damages on top of the other harm. But usually you cannot just sue just for losing money. Okay, vicarious liability. So when is if an employee does something, when is an employer responsible for it? Okay, so when is an employer vicariously liable? They're, well, I'll take this out. Vicariously liable, which just means even though the company didn't do something, their employee did, so they're responsible for it. And that is when you, I don't know, you perform a tort within the scope of your employment. I know that's not right. Let me just look what it says. Well, yes, it is. It has to be conduct within scope of employment, which just means like your job. Acts. Well, okay. And employer may be liable if employee takes a detour. So detour is a legal term of art, and that's just let's say like a very short detour from like your normal route of work. Like let's say you're driving somewhere for work, but you have to stop to go to the bathroom. Things like that. There's another kind of side trip or like a side quest called a frolic. I'm not. Why can't I remember what it's called? I think it's called a detour. I mean, a frolic. Yeah. If the employee takes a frolic, that's a more substantial side quest. They aren't liable for that. So let's say instead of going to the bathroom, they like take a frolic to the casino. You wouldn't be liable for like what they did at the casino. Okay. And usually not liable for intentional torts. So if like your employee does something on purpose, so it's not just negligence or like reckless, but they're doing something on purpose, such as like assaulting someone, and it's not within their scope of authority, then you could be liable for it if you're the employer. Okay. What about if they're not an employee, but they are an independent contractor? Okay. If you are an independent contractor, the employer is generally not liable unless the person who is receiving services thinks they are an employee. And there's one other thing. Oh, okay, never mind. Okay, you are liable. Employer is liable for these things: abnormally dangerous activities, inherently dangerous activities, non-delegable duties, meaning like duties that you shouldn't be giving anyone else because they require like skill. Storekeeper, maintain reasonable, safe store condition, maintain safe work environment, and state safety statutes. Okay. I really like that. Okay. Now, what is the traditional rule for contributory negligence? For contributory negligence, the rule is if multiple defendants are responsible for the harm and one defendant pays more than their fair share, they can go to the other defendants and collect from them. Let's see if I was right. Never mind. Okay, so under contributory negligence, if the plaintiff contributed to their harm, they cannot sue, or they cannot succeed in a suit. Okay. I always get confused because there's two types of comparing how negligent someone is. There's a lot of different types, but the two main types are contributory negligence and comparative negligence. Okay, I have to remember that contributory negligence in states that use contributory negligence, that means if the plaintiff was at all responsible for their injuries, they cannot sue. So, okay, got it. What are the two major forms of comparative negligence? All right. There is pure and modified comparative negligence. And this is like comparing, if it's pure comparative negligence, the plaintiff can recover the percent that they are not at fault. If it's modified comparative negligence, the plaintiff cannot recover if they are more than 50% at fault. All right, let me see if I did that right. And if they're equally at fault, it could go either way, depending on where you are. Okay. When will a disclaimer for negligence not be enforced? So maybe you've if you've gotten on a roller coaster or any amusement park rides or Ferris wheel, you probably had to have signed a liability waiver saying we won't sue you if something happens. But those waivers, while they do protect the company, they don't protect the company in 100% of cases. There's certain times when the waiver does not apply. It will not apply or not be enforced when conduct is reckless or wanton, meaning just completely outrageous, basically. If there's a gross disparity between the bargaining powers of the parties, if it's public service like medical services. All right, so even if you sign a liability waiver with a disclaimer, you may still be protected if it's reckless or wanton or gross negligence. If there is a difference in power between the parties, if they are for public service, like medical services, if signed under fraud or duress, and against public policy, which means just kind of the same thing as, well, against public policy would just mean going against kind of the values of the country. All right, so I need to remember this list. So a disclaimer for liability may not be enforced or will not be enforced when there's reckless, wanton, or gross negligence, when there's a big difference in the bargaining power of the two parties, when it's for public services like medical services, if the liability waiver is signed under fraud or duress, and lastly, if it goes against public policy, meaning against the country's values. Okay. So what does it mean to assume a risk? So you assume, when you apply. So when you sign one of those liability waivers on a roller coaster or whatever, you are assuming the risk, meaning you are taking on the risk. So they're telling you, hey, this is a risky activity, and you signing means you're voluntarily exposing yourself to the risk. So for certain things that happen, you won't be able to sue for. Sometimes you don't sign something, but people may still assume that you've taken on the risk. So if I remember right, it can be implied that you assumed the risk if you voluntarily and unreasonably expose yourself to the risk. And that means that, well, I think that's all I got. Yes. So you must voluntarily encounter a known risk. Voluntarily encounter a known risk. And generally reduces coverage. Okay, so you can assume the risk of it. So if you go skydiving, even you can assume the risk by signing something or by voluntarily and sometimes unreasonably encountering a known specific risk. And that can either make it so you cannot collect any money for negligence, or it can make it so the amount you can collect is reduced. Okay. What about strict liability? Okay, so strict liability is when you are responsible for harm, whether you meant it or not, whether you knew about it or not. If the harm happens, that means that you are responsible. So what is required for a prima facie case for strict liability? And I'm going to write this out. It just means on its face. The foundation. So what do you need? Well, maybe I'll just put like the basics. So like, what do you need to present a case for strict liability? You need to present, if I remember right, that the defendant had a duty to like make sure someone or something was safe. They breached that duty. They caused the damage, and there were damages, right? Yes. So someone had a duty, breached the duty. The breach caused damages, harm occurred. So for prima facie case of strict liability, you have to prove that the defendant had a duty to you or to something, that they breached that duty, meaning like they failed to keep you safe. Their failure to keep you safe caused you harm, and you have to be able to like prove that you did suffer harm. Okay, and this is applied to dangerous activities, dangerous animals, and defective, dangerous products. Okay, so what is an abnormally dangerous activity? I can't really remember the exact definition. What harms from an abnormally dangerous activity is strict liability applicable? So an abnormally dangerous activity is defined as one that creates a foreseeable, I think that's an important part, a foreseeable and highly significant risk of physical harm. So even if you are careful, if the activity presents a significant risk of physical harm, no matter how careful you, no matter how careful you are, it's still considered dangerous. And it has to be an activity that not many people engage in. Maybe this would be like juggling juggling knives, or like torches that are on fire, or like those people who swallow fire. I don't know. To me, that seems pretty dangerous. Also, even like rock climbing, maybe without like the proper gear, things like that. The courts also examine the gravity of the harm, the place, the appropriateness of the location, and the value to the community. Okay, now domestic animals. When is the owner of a domestic animal strictly liable for harm done? So again, strict liability means you're responsible whether you knew about the harm or not. And you're strictly liable for domestic animals when you know of like a specific danger of that animal. So like if you have a dog that you know like attacks people, you will be responsible if the dog attacks someone and you didn't know about it, because you should have been controlling that dog to make sure it doesn't attack anyone. Let me make sure I'm right. Yes. If the pet has dangerous tendencies and harm is a result and cause harm. So if you know, like I said, if you know that your pet like attacks other animals or other dogs and you're not keeping an eye on it, you're going to be responsible whether you knew about it or not. Now, if your animal has never ever been like violent or aggressive in the past, then you won't be strictly liable. You might be liable in other ways, but not automatically. But if you knew that your pet was dangerous, then you are automatically responsible. Okay. Now, strict products liability is when, what about if you get hurt by a product? And when is the like manufacturer or the seller who's responsible for you getting hurt? Okay. To make someone responsible for getting hurt, strictly responsible, you need to prove three things, I think. You need to prove that the product was defective, that it was defective when it was in the control of the defendant, and the product caused the plaintiff's injury. So, defendant is responsible when the product was defective. Two, the product was defective when the defendant had control of it, like before they sold it. And three, it was used, cause harm when used in a reasonably foreseeable way. So I can't think of a great example right now, but if you use a product in the way that it was intended and there's something wrong with it and you get hurt, then you can likely make the manufacturer be strictly responsible for it. Meaning like they don't have to prove, or you don't have to prove that they like knew about it or intended it. You just have to prove that it happened. But that's only if you're using it in a reasonably foreseeable way. If you use a product in a way that like the designer or manufacturer would not have expected you to use it, then they wouldn't be strictly liable. Okay, so what does it mean for a product to be defective? Defective means it deviated from like what the manufacturer intended. So you do that by like comparing what the kind of like what the specs or like the blueprint of the product was. You compare what the product that you received to the product they intended to make. And the differences are the defects. All right, let me make sure I'm right. Okay, kind of right. So manufacturer defect is what I just described. Deviate from product specifications. But you can also have a design defect. And that's determined by two tests, which is the consumer expectancy test. Yeah. And the risk utility, yes. And the law like loves tests. So when whenever I write tests, what I'm talking about is can't I spell expectation? Ways that the court decides something. So the court will decide if there's a design defect by running these tests. So the CE test, the consumer expectation test, you ask yourself, or the court asks itself, was it unreasonably dangerous beyond what a user would expect? So more dangerous than a user would expect, let's say reasonably. Okay. Now the risk utility test is if there was an alternative design that was safer. Alternative safer design is available. Okay. And then the last type of defect you can have is a failure to warn defect. And that's when there's a not obvious, foreseeable risk of harm that could have been avoided with instructions or warnings. So, foreseeable risk of harm not obvious that could have been reduced by instructions or warning and making a product unsafe. Okay, I need to go over these. Okay, so for strict product liability, to establish a prima facie case, you need to prove that the product was defective, that the defect caused harm, and that harm occurred. To prove it's defective, there's different types of defects. A manufacturer defect is when the product differs from what the manufacturer intended. So you compare what you got to like the specifications that the manufacturer decided to use for the product. If it's a design defect, meaning it does match the specifications, but it's still unsafe or still hurt you, there's two tests that the court uses to decide whether there actually was a defect. Sometimes they only use one test, sometimes they use both tests. It just depends where you are. But the two common tests are the consumer expectation test, which is just, was the product like more dangerous than the user would have predicted or expected? And then the risk utility test is asks, was there an alternative safer design? Was it even possible to make it safer? And then final type of like defect you can claim is a failure to warn. So if there's a non-obvious risk that's foreseeable and the manufacturer does not give instructions or warnings on that risk, then that is also a defect. And they can be strictly liable. This means you're liable whether you intended to cause harm or not, whether you knew about it or not. Just because you made the thing and it hurt someone, you're responsible. Okay, who may you sue for strict products liability? So if a product hurts you, who can you sue? I mean, I believe you can sue. Let me look. So you could sue, oh, okay, you could sue the manufacturer, the distributor, or its seller. So usually like a product will be made in a factory and then get sent to someone who purchases it, who sells it to a bunch of stores. Okay, so who can defendant to be a defendant in strict products liability, you need to either be the manufacturer, the distributor, or the retail seller. Yeah. If this, okay. What type of damages are permitted for strict products liability claims? Not quite sure. Personal injury or property damage. Okay. Can only recover for personal injury or property damage. So no economic loss. If it's an economic loss, you bring it under a different claim. Okay, I need to remember that. So strict products liability, you can only recover personal injury and property damage. Okay, what happens if a plaintiff was negligent and they still bring a suit for strict products liability? Perhaps it depends on where you bring it. Yes. All right, I don't need to take that note. Okay, now nuisance. So this is like a land tort. So a private nuisance is when a thing or activity interferes with your enjoyment of your land. Yes. And a thing or activity or person interferes with quiet enjoyment of the land. Well, quiet enjoyment and use of it. Okay. Hey, Chelsea. I finally got through all of corporations. My corporations flashcards are coming up soon. Okay. And if the person complied with laws, it's not a total defense, but it is partial or like helpful, I think. Yeah, not a total defense, but can be evidence. But can be evidence of reasonableness. Okay. What are the elements of defamation? Defamation. Okay. It's a statement intended to be communicated to a third party to, let me start over. It's a statement that is about somebody and is told to a third person and damages reputation. Okay, statement communicated about somebody to a third party who understands that it is defamatory and the statement actually harms reputation. Chelsea, were you in Andy's live earlier? I don't know if you were in. I don't think you were in there. She was going over some court documents. Okay. So I need to say this one more time. If defamation is a statement communicated to a third party who knows that the statement is defamatory about a specific person and it actually does harm that person's reputation. Okay. If it's a matter of public concern, then you have to prove that the statement was false. If it is involving a public figure, then you have to prove it's false and malice, right? So public concern must prove false. Public official or figure, you have to prove it is false and actual malice. Yes. Okay. What is the distinction between libel and slander? Alrighty. Libel, oh gosh, is spoken. No, libel is written, and that includes TV and radio broadcast. Written defamatory. Written defamation includes TV and broadcast. Or sorry, TV and radio. What effect does this have? Okay, I don't know. And you can collect damages for libel. Slander is written. I'm sorry. Oh my gosh, spoken. Spoken, gesture, or any other form of defamation that's not libel. And to recover money for damages for slander, you have to prove that it's slander per se. And there's a list of things that people say about you automatically qualifies as slander. Okay. Damages only if slander per se. So not all slander you can sue and get money for. Certain types. Right. And I'm sure I'll get a flashcard about those types. What defenses are available to a defamation action? Truth is a total defense to defamation. So if the thing is true, then you are completely covered. So truth is complete defense. I believe consent. So if the person consented that you publish or say this, if it's made in court, well, let me write these down. So the truth is a complete defense. Consent is a defense. If it's a statement between spouses, that's a defense. Made in court or legislation, that's a defense. Required to make the statement. So like if you were, I don't know, you were required to say this like on TV or something as a news reporter. Okay. And then you can have, I need to look up the difference between qualified privileges and are these absolute privileges? Yes. And, oh, you just got up, Chelsea? Yeah, it was a good show. You can also use qualified privileges, which are okay. And you are responsible if you, sorry, you may not be responsible if you have made the statement in interest of the defendant, interest of recipient of statement or third party, or for a public interest, then have to prove actual malice. Okay. So complete defenses to defamation are truth, consent, statements between spouses that are made in court or legislation, and if you're required to say it. You may also be able to defend yourself if it was made in the interest of reputation or to help the recipient or third party or for the public interest. If the plaintiff can prove you did that with actual malice, you would still be responsible. Okay. For invasion of privacy torts. Do I remember all these? I need to go back over these. I know one is intrusion to seclusion. And I cannot at all remember the others. Maybe it's, I don't know, it's 3. It's not even early. Misappropriation of the right to publicity. And I'm pretty sure that one is like when you use your name and likeness without authorization. If placing plaintiff in false light and false facts, or no, public disclosure of private facts. Okay, intrusion, misappropriation, false light, public disclosure. All right. There are 4 actions under invasion of privacy. Those are intrusion to seclusion. I should make this bigger. Okay. Sorry guys, give me 1 second. Okay. Next, what's my next flashcard? Elements of intentional misrepresentation. Okay, I think I'm going to take a break for now, but thanks guys for stopping by. I'll probably be back on in a little bit. But yeah, thanks for studying with me. I will catch you guys later. Bye.